The Nation Station, RTC, the Nation Station, the Nation Station, RTC, the Nation Station.
Welcome to the Financially Speaking. I almost say welcome to the Drexwell Seymour show. Welcome to Financially Speaking. And this is the first Tuesday in November. And I tell you, boy, soon will be 2026. Mm-hmm. And we give God thanks for bringing us this far in the year. I know we still have about 26 more days left for the hurricane season, but I'm so grateful to God that He spared the Turks and Caicos Islands. Of course, I'm very it's very unfortunate what happened in Jamaica, and I encourage all of us, whatever we could do to help Jamaica, please help, because if it happened to us, I'm quite sure other countries will be helping us as well. And remember to pray for Jamaica. Even if you can't help financially, at least pray. If you know people there, just give them a call. Just encourage them and support them. Of course, be very careful of if you're giving money. Be very careful who you're giving money to, because there are so many scams out there. You don't know who's who. So be very careful. I believe the government has announced the organizations that you probably should be funding. So I want you to be encouraged. And let's pray for our sisters and brothers in Jamaica. It's really sad. Some people up to this date, have not heard from family members. One of the nurses in the dialysis center, she still has not heard from her grandfather. So, let's pray that some contact be in place. I think it's probably because of the loss of telecommunications, I'm assuming. So let's pray for the people in Jamaica, and let's give God thanks. Every day I wake up, I say, Lord, thank you, thank you, thank you, thank you, thank you. And with that said, today, our show, we're going to be talking about estate management. I know we had this topic, we talked about this before, but it's been a couple of years now, and I've ran into so many different people who do not have a will, who have a will and are having a lot of issues. And I think it's important for us to talk about this topic again, and it's important for us, I believe, to have a will. And with that said, I want to welcome Honorable Akierra Missick. I think she deals with estate management in the firm that she works. And I thought she did a very good job before talking about it. So I said, well, if she did a very good job before, then why not bring again? And so with that said, I want to welcome Honorable Missick to Financially Speaking show. We're going to talk about it's nothing to do with government. It's about will and estate management. So thank you.
Thank you very much, Drexwell, for having me, and to all your listeners and supporters of Financially Speaking. And I want to apologize now. I'm beginning to feel that I'm going under the weather. And so if I have a sniffle or need to take a sip of the ginger tea, please forgive me.
Oh, you can't prepare your tea.
I did.
Good for you. Good for you. So, how are you doing, by the way?
I'm well, besides possibly the sniffles that want to descend. I missed the flu shot, so I want to encourage people to get their flu shot, as I may be suffering because I forgot and wasn't here to have it. But otherwise, everything is well.
Good,
I have no complaints.
Good. Very good to hear that. With that said, let's go straight into our topic.
Yes.
What is estate management? What is that for the average person on the street?
Yeah, the global phrase of it is death is going to happen. And as responsible persons, we should prepare for that eventuality as best as we can, especially if we have children, property, assets that we want to be distributed in the way that we want it distributed on our death. And so that's the global concept of estate management and estate planning. It's where you, the individual, take the time to make a decision on how you want the next phase of your belongings being distributed upon you going ready to meet our Maker.
Mm-hmm. And so why is that important?
It's important especially because when a person passes away, it's already an overly emotional time. And I think we've heard it several times that funerals and weddings really can break families up.
Tell me about it.
Yes. And so as a culture where we're very close as family members, and in some instances we do have children with different partners, but we're all part of one family. What I've seen in practice is persons who have passed away without a clear set of instructions kind of descend into chaos and competition. You will hear things, well, I took care of Ma, y'all weren't around, y'all ain't know how she eat, and now that she's gone, you want the house, you want the land, you want the jewelry. And so in order to not have that extra level of emotional decision making after your passing. You're giving your family, your friends, your church a gift of saying, I've made these decisions and this is how I would like my estate to be distributed on my passing.
Okay. And then based on your experience in estate planning, what are some of the misconceptions?
Misconceptions is that children born outside of wedlock are not entitled to any gift. A lot of persons and clients I have would say, well, that's my outside child. And the legislation equates all children equally. Then some persons don't understand that if you had a will prior to your marriage, you need to update that will, because once you are married, your spouse now gets automatic provisions made in the intestacy ordinance for their benefit if you pass away. And so if you don't want to leave your spouse 50% of the estate, you need to make that abundantly clear that that's not the wish that you want to do. Other issues would be finding siblings. Again, over the years, finding your siblings. So over the years, we had a lot of men who sailed and may have formed families in the Bahamas, Turks and Caicos. Persons have emigrated to the United States, moved around the world. And if there isn't a will, then in order for the letters of administration to be applied for, you need consent from all beneficiaries of the estate. And so all. So that creates a lot of headache. We have clients who say, well, I haven't heard from this brother. This is my father's oldest son. He was born in the 60s in the Bahamas. I don't know him. I've never met him. But you know that there's a beneficiary out there that would have a claim in the estate. And so again, it provides you an opportunity whilst you're alive to say 10% to Drexwell, 10% to Akierra, 50% to Church of St. Monica, without then everyone coming towards the end going, well, where's Tom? When last you spoke to Mary Lou? Did so-and-so pass away at this time? Are there any nieces or nephews that we need to reach out to? Or siblings who are no longer, communicating, estranged siblings. See, we have good relationships because we're in contact with our siblings, but not every family has that sort of relationship.
Okay, so you're saying, I want to go back over that last one. You're saying in order to be an administrator, you need the consent from all
potential beneficiaries. So if someone dies without a will and they have 7 children, and one of the children decide, okay, I'm going to apply for letters of administration of our father's estate, if the other siblings who are the beneficiaries, and if he left a spouse, do not consent, then it becomes a contested probate, and you would need to convince the court why you should be appointed the administrator over anyone else, now that the other beneficiaries have not given consent to you being appointed administrator. So you're looking at increased costs and time and delay.
Wow. So I thought, well, that's the law, I guess, but I thought once a majority of beneficiaries sign, then it's okay.
That's helpful, because then again, you're convincing the court. So if there's 7 and 5 sign, including the one who's petitioned, and you have 2 that are like, no, then the court can be encouraged to grant it because the bulk of them have agreed, but that would require a contested hearing. Where you do not require a hearing is if all the beneficiaries consent to Drexwell being appointed as the administrator of the estate.
Oh, that's interesting. I'm glad you covered that. And then you mentioned about the, we say outside children, but they're children. They're children.
Yeah, they're all children.
I know we like to say outside kids, or what they call it.
Culturally.
They like to use the word illegitimate and all those different things. But you're saying that all the children, whether it's inside the marriage or outside the marriage, are equally entitled.
Yes.
But those children must be proven that it's DNA connected, right?
If there is a challenge. So if I say, well, no, you're not my father's child, I know you're not my father's child, I can make an application to the court for a DNA test to prove the connection there. But I mean, it's assumed, especially if the father's on the birth certificate.
That's good. If the person's on the birth certificate, I can understand. But what if the father is not on the birth certificate?
You could have an application. In some instances as well, we've had affidavits which would say, well, I knew this was my father's child, and you could have the other siblings confirm that, or family members of the father's estate. So I've seen affidavits where the mother of the father, who had passed away, said that this is my grandchild. My son told me that about this child. My son took care of this child, and they would also be included. But if there's a complete disengaged breakdown, then a DNA test can assist.
Okay, that's good. And so we talk about and then you mentioned also about the wife. You say if you had a will before marriage, you should update your will.
Yes.
If you don't update your will, the wife doesn't automatically...
can challenge it.
She could challenge it?
She can challenge it because the intestacy ordinance provides that if there is no clear will, spouse is entitled to 50% of the estate, and then any other beneficiaries will share the other 50%. So if I'm a wife of a man who has passed away and he didn't update his will to include me, I would challenge his will because the legislation says I'm entitled to 50%. And so that's the reason why we say update the will after the marriage, even if you leave it drafted the way it was prior to the marriage, but you've changed the date to show that it's after the marriage, then the will is honored. And there cannot be a challenge then unless the spouse can prove that you were not in your right sound and mind.
Okay, so the wife could get 50%, and the other 50% is for the children.
The beneficiaries.
So, what if the wife met her husband with all these assets before they got married, and there was no will? She's still entitled to that?
Yes.
Is that right?
Once married. If there's no will, you're subject to the ordinance. You see, and that's why you're encouraged to make the decision while you're alive how you want your assets to be shared on your death, because marriage does change that. So now she becomes a spouse, or he becomes a spouse, because a man can meet an equally wealthy woman as well without a will. The legislation says if you have not made the decision yourself, the legislation will make a decision for you. And the decision is 50% to the grieving spouse.
That's interesting. And so, I want to talk about marriage again.
That's fine.
Because I know
I'll come on the show and do the divorce ordinance with you.
Yes, because I know a lot of people are experiencing this.
Oh,
right?
Boy. Write your will.
That's important, because what's happening is there are some marriages where we know that the spouses were not together.
Okay.
They were not legally separated, but they were not living together as husband and wife. But that wife is still entitled, I guess, because she's legally...
Yes, she is. She's still entitled. Because until you're divorced, you're married. Whether you're separated or not, you're married. Now, if you go through the judicial separation process, that's a different kettle of fish, which can say, okay, as of today, November 4th, what you have is yours, what I have is mine, and we're judicially separated. That may put another spin on it. But again, the best advice is make the decisions while you're alive, you're well. We are all going to die. We do not know when. So there's no point saying, because I've heard it, I've had people call me and say, well, I don't want to do a will because it means I'm going to die.
I heard that too.
Baby, you going to die.
Yeah.
All right? Whether you like
Exactly.
it or not.
Yeah.
It's not going to jinx you.
Exactly.
But what you would do is provide a clear plan and intention of what assets you have and how you want them distributed on your passing.
Yeah, I told a friend of mine too, and because he's married to this lady and they didn't have any children, but he has, I think, about 5 children at that time, and I was concerned that if something would happen to him, you know, the wife would get everything and those children would not have anything. Of course, I didn't know the law, and I was telling him, you know, I think he should, you know, get a will. He said, no, I ain't getting a will. That means I can die soon. You know, you're right.
Listen, people are passing away at various ages.
Yeah.
You know, you have young, because Greg and I were just saying that when we came in. Yeah, I got the aches and pains, and my knees hurt because I'm getting older and I'm heavier. But it's a pleasure to have seen the age of 42. I have 3 very close friends who will never see this age. They passed away in their 30s. And so it is a pleasure getting older with all the aches and pains that come with it.
That's the way of looking at it.
But at the end of the day, we are all going at some point.
Yeah. and that's something we have to
and
to
don't be
face.
afraid of it.
Yeah, because we can't control that.
No.
It's our time is already assigned.
Yeah.
And that's why it's important to do a will. But and so, at what point do you think then that we should start with doing a will?
Well, if you have children, for sure, definitely, whether you're married or not, I think you should make some sort of provision, because especially if your children are underage, you want some guardianship provisions in there as well. If you have a good relationship with the other parent, then of course, if you pass away and you're the primary caregiver, that parent would be assumed to take over that role. But what if that relationship is so rocky and that parent has no relationship with that child? Wouldn't you want to make a decision to say, okay, I've passed away, my child and my sister have an amazing relationship. I know she's going to raise him and take care of him like her own. I want to make provisions for his continued care if I pass away. And if you have assets, what you don't want to happen is you pass away and the bank now freezes all the accounts and it's sitting there waiting for 6 months for persons to argue about who's going to apply for letters of administration, who's going to pay the legal fees to get the application, because we find that there's a lot of delays in these applications because persons are like, well, I don't want to pay the fees. You hire the lawyer. But once the lawyer does the work, then there's an issue on the next end, because the person who's paid the funds up front then say, well, since I paid for it, I should be able to get more. And it is a big responsibility administering on an estate. It is a legal responsibility you have when you do step up to the plate to do so. But my advice is, if you have assets and you want to make a decision on how they're distributed on your death, draft a will. And definitely if you have children or dependents. So even if you don't have your own natural children, but you have dependents. For me, I don't have natural children, but I have nieces and nephews. And so when I pass, I want to make sure that they are also gifted something from my estate as, you know, another indication Attorney Akierra loves you and wants you to continue, you know, doing well.
Okay, that's good to know.
Yeah.
So,
and don't forget your church as well. I always put this in there. And whenever I draft wills for people, I always say, are you affiliated with the church? Because you could always leave a gift for your church too.
Oh, okay. That's good. So, I know we talked about this when you was on the show a couple of years ago. So how do we go about doing the will? I mean, and how do we go about registering the will? What is the process in doing a will?
Well, the easiest way is instructing an attorney to do it. I know that has cost prohibitive measures for persons, but that's the easiest way, because all the law firms have a will depository, and so your will is secured and safe there. And once it's drafted and executed, done by the witnesses, it's filed in our various systems. And so when you do pass away, usually emails will go around, do you have a will for so and so? And one of the firms would say, yes, we actually do. And then you're able to advise the family, so and so had a will. We're happy for you to come meet and, you know, go through it with you to explain it to you. But the other option is you do it yourself, which isn't a problem. You just have to ensure that whoever's witnessing the document is not a beneficiary. So whoever the two witnesses are cannot be someone who will receive a gift from you on your passing. And secure it in a safe place. I normally tell people, if they do it themselves, do 3 copies, one that they keep, one that they give to someone they trust who can, you know, keep it safe and sound for them, if anything, and then one in the house in case when the house is attended to after your passing, it can be found there. The basic information needed in the will is it needs to be titled Last Will and Testament.
Last will and testament.
It must be dated.
Okay.
Because there could be challenges on whether a will is prior to the last one, etc.
Okay.
yourself. So, I, Akierra Missick of 6 Rockstar Lane, Providenciales. It's my final will and testament. List your assets and then the distribution. So, my sister Alexandria, my nephew Aiden, my nephew Dominic, etc.
Oh, okay. And okay, I know you talk about the.
And there's so many online templates now, to be honest with you. I've had a lot of clients who will do it first online
and then bring it
and
to
then
you.
Send it to me and ask me to make sure it fits within Turks and Caicos.
Yeah, because you want to make sure you cover everything. But okay, But don't you have to file that with one of the government departments?
No, so you can have it registered at the deeds registry, but there's no requirement for it to be filed.
Oh.
No, you
That's
just
a
want to keep it
deeds
in
And where's the deeds registry?
both Grand Turk and Provo. I think the main office is in Grand Turk, and it's where births, deaths.
Oh, okay.
Registrar.
The registrar. Okay, so
Yeah,
you
so
don't
the
have
registrar
to-
of deeds would be, but no, it doesn't have to be filed.
Okay.
There's no obligation for it to be filed anywhere, and I think in due course, we did have a seminar on the probate rules a few months ago. There is a push to create a wills depository, a national wills depository. So I believe further discussions will be had with the Chief Justice, and then this would just be a quasi part of the probate and administration arm of the judiciary.
So let's go back to something. Say I have this land, right? The land is registered in my name. And then say I put one of my children on it,
Okay.
and say I were to die, God forbid right now. I have 5 kids. But what if that one child whose name I put on the land registry, say, well, the land is in their name.
So,
Can the other 4 children contest that?
well, that child is protected by the registered land ordinance as the proprietor because they are a joint proprietor with you. And the registered land ordinance provides that on the passing of the other joint proprietor, the property automatically vests completely into the other person. So that child would have 100% of the property. Now, if you and your child had placed it as tenants in common, which means you have 50% of the property, they have 50% of the property, then by virtue of your will, you can decide how your 50% interest would be shared out on your passing.
So tenants in common.
Yeah.
Okay, so that's good to know. So tenants in common mean
50%,
sharing it.
50%. Joint proprietors, it's 1. We share it equally. Anyone who passes away prior to the other one, 100% stays with the person who's registered.
I see. Tenants in common. Okay, that's good to know, people who are listening, because there are situations.
Of course they are, and most people put their property as joint proprietors. Tenants in common, from my practical experience, happens when 2 individuals are not yet married and they're purchasing a home or a property together, and they've put 50% equally into the purchase price. So that way they want to protect their investment or their interest in the property differently than, say, a married couple would, because you're married, and so to become one, and joint proprietors would be the normal course of action in that regard.
Because I know of a situation where, because I don't think that parents meant for it to be that way.
No.
Where even though they just put that one child on there.
Depends on relationships too.
Yeah, and so I don't think that was the intent.
No, probably
and
not.
And I think that's why it's very important for us to do that joint, what do you call it?
Tenants in common.
Tenants in common.
Or proprietors in common.
Yeah, because there are situations I'm aware of where, some people just left out. And they're saying, well, your father or your mother's name is not on here, so
Yeah,
you're not
dog eat
entitled
your
to
rice.
it. And-
Another way that if persons are considering the property transfer, because remember there's no stamp duty if you transfer property to your children. And so if it's the case where your parents are getting older and they're considering that, on their passing, they want you to have this property, you could do that transfer now and then the child then enters into a long-term lease with their parent. So that way, when the parent does pass away, if it was their intention that this property should only belong to one child, then the child is already registered as the owner of that property. So that's another way that you could look at it, and that's part of the global estate management preparation that attorneys can provide, because saying draft a will is straightforward. You have one house, you have 3 children, all 3 children get the house, but when you get into the complexities of, I have a business, I have other property, I have rental property, and this child has shown that they're interested in the business affairs and in continuing managing the business, you may want to assign the shares of the business to that child, whereas the other child may be more into the property aspect of it, and there'll be a good landlord, and so you want to transfer property that way. You get to decide that whilst you're alive.
So what about families considering putting it in a trust?
I've had a lot of inquiries about trusts recently.
And what is a trust, by the way, for those watching? Yeah.
I don't even know what a trust is. It's so confusing. But a trust is a legal vehicle that provides for a trust, a gift giver, because I was going to use all the legal terminology, but I'm not going to do that. I'm going to make it as plain as possible. A gift giver to put the assets in a legal vehicle that then designs or identifies the beneficiaries of those assets and what those assets can generate, whether it's rental income, whether it's the property or the company operation, to then be managed. So once the gift giver gives it away to the trust, then you have a trustee that decides how the assets are to be determined, managed, liquidated if needs be, for the benefit of the beneficiaries. Trust, I would recommend if matters are very complex. If it's a straightforward estate matter, then I think a will is more than sufficient. The only difference about a trust is that you've already given the assets away while you're alive, and so you don't have to go through probate on your passing. Whereas probate can take 3 to 6 months depending on how organized the application is and the supporting documents. It's not overly cumbersome in that regard, but if you are doing it for tax planning purposes, which tends to be why a lot of people would go into trust management here in these islands, we don't pay income tax, so there's no real incentive to do it locally. But internationally, that's some of the reasons why we would get those sorts of inquiries in for it.
Okay. So, I lost my train on the wheel. But I want to go back to the marriage thing, right? Where you say the wife is entitled to 50%.
Spouse.
The spouse.
Yeah.
If
there's no will.
That's true. I say wife because it could be husband too.
Well, to be honest, women live much longer than men. So more than likely it's going to be a wife.
All right. So what if the wife says, okay, you got this no will, but you got these assets going on, and the children are saying, well, that's my daddy land or that's my daddy property, and the wife is saying, no, that's not, that's mine. How will that work when the wife is saying that's her asset and it's not really her and her husband's assets, or this, like vice versa, the husband and wife?
And this is prior to the letters of administration being granted.
Right.
So it doesn't belong to anyone until the letters are granted. The applicant, which could be the spouse, or it could be some other beneficiary who makes the application for the letters, would petition the court, set out the inventory. The court's rule is that 50% of the estate would go to the spouse if there's no will. So then you look at liquidating the estate, or you value it. So if it's 4 pieces of property, 2 pieces to the spouse, 2 pieces to the other beneficiaries. And in that regard, by following the legislation, the property can be transferred to the spouse.
Yeah, but what if the wife survived, the husband died, but the wife bought a piece of property personally?
That's okay.
Will that still be part of the estate?
No.
It's not part of the estate?
No, it's part of her estate, but not the husband's estate.
But if the husband had lived, the husband could claim for that, though?
If she passed away before him, yeah.
I see. I see. Okay, someone asks, how often, let me make sure I get the correct questions. How often can they change or rewrite a will?
As much as you want. As long as there's no limit to it. We would recommend that you look at what you're acquiring. So say you wrote a will 5 years ago and the only asset you had was your home. You've worked very hard over the last 5 years. You found some good lending opportunities in the islands, which are very few and far in between. And now you've built a 10 apartment complex. You want to update your will to include that. Okay. If you've bought some expensive jewelry or something that's significant to you that missed the original will, then you want to update your inventory. If you've fallen out with people who you were previously going to give a gift to, then you want to update it then. What we do not recommend is updating it every month, because then it becomes a bit silly, and if you do pass, it could be challenged that you kept changing your mind, and so it shows that you were not of a sound mind when you were making these decisions.
Yeah, and speaking about that, I remember when you was on the show a couple of years ago, you mentioned that you must be of a sound mind.
Yes.
When you're doing a will.
Yes. So I've seen situations where people have had wills signed while they're on death's door at the hospital, and
So that can be challenged.
they have been challenged and successfully challenged. Yeah. So you want to be in a sound mind. You don't want to do it when there's any emotion. You don't want to do it right after a divorce. Well, maybe you do want to do it right after a divorce. If the spouse is in the will, I would recommend that. But you don't want to do it right after the breakup, before the divorce, because you may reconcile, you know what I mean? But once the ink is dried on the divorce papers, sure, change your will then. But you don't want to do it overly, exactly, overly emotional, and you're not thinking as clearly as you probably would on a plain Wednesday afternoon when you decide, okay, I have a 3 p.m. meeting with my will drafting attorney.
Right. Okay, so let's talk about now that the owner of the estate has died, it's time now to distribute the will.
Yeah.
Say there's a will.
Yes.
It's time now to distribute the assets. What advice would you give to the administrator? Because there are a lot of, we have a lot of conflicts with families.
We do.
Say they sell one of the assets. What advice would you give to that administrator to make sure that whatever the way they manage the estate is transparent?
Yeah.
Well, what advice would you give?
Well, the best advice is if you're administering it based on the terms of the will, then you be clear on that. So any correspondence you send to the beneficiaries on any actions you're taking, it must always link back to what the will had intended. So if my will says, I want you to sell my home in order to fund education for Lacey, Lathan, Aiden, Dominic, Payton, then the administrator must ensure that they sell the home and put that pot of money aside for that purpose. If a person dies without a will, the administrator must administer the estate in accordance with the ordinance, 50% to the spouse, 50% to the beneficiaries. In administering the estate, that could mean liquidating everything and giving persons cash. If there's a spouse with the 50%, if the home is the 50% value of the estate, they should remain in the home if that's their desire to do so, and the other assets are then liquidated and distributed. But you always want to be clear and concise in your communication, and try not to let beneficiaries pitch you against the other beneficiaries in that instance. So if you have 3 beneficiaries who were born inside of a marriage and 2 beneficiaries who were born outside of the marriage, don't let the children who were born in the marriage gang up on the other 2 who are outside, because I've seen it done. I've seen it. It's uncomfortable, and
the best is to treat everybody equally, Ben.
You have to, because that's what the law says.
Yeah. But okay, so should the administrator then show everything? I mean, okay, so we have a list. Say we have, I don't know, I have 3 homes, whatever, or 3 apartments. Should the administrator say, okay, call the family together and say, okay, guys, this is the assets of our parents. Apartment A, apartment B, apartment B. Is that how it should work?
Yeah. Yeah, because if there's a will, there's an inventory. If there isn't a will, in the letters of administration, you'll create an inventory. So you'll spend time preparing everything to say, well, this is what mom and dad had, or this is what person who's passed away has. And as the administrator, you have an obligation to meet with the beneficiaries and to provide regular updates to them. Because if a beneficiary is of the view that you are not carrying out the administration of the estate properly, they can challenge it in court.
Okay, so say then there are 5 children, and say one of the children died before the parents died, but they had a will for all the children. Can the children of that deceased person challenge for the portion of their father or mother?
No. So
Really?
the gift ends with death. And
So the grandchildren get anything?
not directly, so I'll explain it this way. The gift ends at death unless provisions were made in a will for the grandchildren. So again, I don't have any natural children. My sister doesn't have any natural children, but in my will there's a provision that if she does have children, then this is the gift that I would like them to have.
But what if the will was for all the children, and it so happened that one of the children died? Wouldn't that be a different scenario?
Well, if the parents are still alive, they can amend the will and include the grandchildren.
But what if the parents died, but they left the will for all their children to have something?
and
And
then
one
a
of the,
child dies.
and one of the children died.
Well, then that child's estate would benefit from that gift. See, I thought the
Oh, okay.
parents were still alive
Okay.
at the time, because then they could make the change then. But if the will has been proven, letters of administration was issued, and the estate was starting to be administered on, the child who is a beneficiary who then dies, during that process, their estate should receive that benefit nonetheless, because that was the intention of the parents or the will originally.
All right. But so it's different than if they wouldn't. If again to my earlier scenario. Okay, I got it.
Yeah, because the parents could always, make an addendum or change to say, Sally has passed, but she has these 3 beautiful sons. So what we would have given to Sally, we now want to give to our grandsons.
Got it. Got it. I just want to tell people, I'm getting these calls from Scotiabank by WhatsApp. That's a scam. Okay?
That's a scam, because
It's a
Scotiabank is
scam.
not called by WhatsApp.
Yeah, I just got another call. Don't fall for those things, please. Don't fall for it. Okay.
We're going to be in a scam season.
Yeah, they're calling you. Don't fall for it. And Scotiabank is showing up on the call.
No,
Okay.
and you don't have Scotiabank on your WhatsApp,
Yeah.
so you know.
I just want to put that because I just got a call.
Okay.
All right. So we're talking more about individuals, like
Yeah.
more individual homes. What about a business? Say you have a business, and you're the owner of that business, and you died. How does that come into effect with the distribution?
Well, the shares. So if it's a limited domestic company, incorporated company, and you're the shareholder that passes away, in your will, you can designate how you want the shares to be distributed. If you die intestate, then the shares are property, they're movable property, and they would follow the intestacy ordinance guidelines if you die
Okay.
without a will. But remember, companies don't die, they can only be liquidated.
Okay,
So
okay.
the company will go on for forever,
Unless they decide
even
to
though
sell
you,
it or whatever.
yeah, even if you've passed away.
All right.
Now, who's going to manage and operate the company? You can make those provisions, but my best advice would be, in your will, deal with the shares distribution, and in your company's contingency plan or forward planning, if something happens to you, you should have a plan on who will manage this company, how it will be taken over, etc. That should not be in the will, because a will is for an individual, and a company cannot have a will, but you can have a business continuity plan in that regard.
Oh, so will is for individual. So in your will you cannot say anything about the company distribution.
No, you can, but you can say, I want Akierra Missick to manage this company on my passing. I mean, you can say it, but my best advice is put it in a business continuity plan, because that would change more frequently than your will would change. You may have me in mind today to take over from you if something were to happen this year, but next year I may move away. And you've put it in the will, and I'm like, well, I'm in Japan. I'm not coming back to run your business, So in that regard, I would advise deal with your business moving forward in a continuity plan. But in your will, you can say, I want the shares of this company to be transferred over to Akierra Missick, or obviously you're married with children, so it would go to your family there.
So how can we make sure that the administrator is carrying out the wishes of the will? How can we make sure that it's done?
Court. So the court would set out the rules for the administrator. They're bounded to carry out the wishes in the will, and the beneficiaries would know what those wishes are.
I see.
If they're failing to carry it out, you make an application to the court to either have the court instruct them or have them removed and replaced with someone else who will carry out the wishes as described.
And does that require all the beneficiaries to take it to court, or one
Just one.
of the beneficiaries could take it to
Yeah.
court?
Just one. I always recommend if there's several beneficiaries, do at least two, so that you can't say, well, I told XYZ to do this and they didn't do it. And then you're like, well, you didn't tell me this. And it's always good to have a witness, is what I like to say.
But you must have grounds to take
You have to
it.
know. So in some instances, if they're, say, let's use property as the easiest thing, the administrator puts a property in their name, right? And the will clearly says this property belongs to all three of us, but you've only put it in your name instead of including me and the other person on it. So I could go to the court and say they're not following the will because the will says that on my passing, this property shall, go to these three people.
I see. Let's talk about the administrator, because I
It's a
get
lot
the
of
impression,
responsibility.
but I get the impression sometimes that the administrator feels like they own the estate.
Yeah, sometimes they do.
Really?
That's not their responsibility, but sometimes they do, especially as I've seen in practice, if they're the ones who paid to get everything arranged. They've paid the attorneys, they've gone to court, they've submitted the information to the Gazette, they went to the land registry,
But
they
they
got
could
the
get
documents.
reimbursed for that, though.
And they should get reimbursed for it. But in some instances, you have people who think, well, since I've done all the work, I'm entitled to more. And then, unfortunately, for the other beneficiaries, if they're not tracking or paying attention and they let things go by the wayside, they can lose their assets. A lot of administrators sell assets very quickly as well.
So they have the power to sell the assets with the beneficiary input?
They shouldn't. But once the letters of administration is granted, then the property that was in the deceased name can be transferred over to the administrator, because their name on the property will now be Akierra Missick, administrator of the estate of XYZ. So that means I have full power to do what I need to do with the property. But if you're an administrator and it's clear in the will that this property should be transferred to Alexandria, Jamal, and Akierra, it wouldn't make sense for me to put Akierra Missick on there alone. When I'm having the register updated at the land registry, I need to have Alexandria and Jamal included as well. But you'll have some people who would say, I've done all the work, I'm the administrator, and so I've done it this way because this is the easiest way to do it, and now I will work on distributing the estate. And in that way, you have a remedy with the court in showing that the administrator is not carrying out the affairs of the estate in a fair and prudent manner in accordance with the law.
I see, because I think the administrator, as far as I know, basically it's just like the manager, or
Yeah.
the administrator does not own the land,
No, doesn't own the asset.
doesn't own the assets.
No,
And
they're
I
the
think we need
manager
to
of
make
the
that very
assets.
clear, because sometimes, because you're the administrator, that doesn't mean that those other people do not
matter. Yeah.
They still have equal rights as you.
No, it just means that in place, an administrator or an executor is a legal replacement of the deceased. That's all it is. It doesn't mean that you get to make decisions that the deceased would not have made. It just means that the deceased
Somebody
is now
got to act
gone.
on behalf.
Someone has to go to the bank.
Yeah.
Someone has to go to the land registry. Someone
Yeah.
has to go to Fortis. So that's all it is. It's giving you that power and authority to speak on the deceased's behalf at these entities. But that doesn't mean that you can now start using the deceased bank account as your own bank account without following their wishes.
Yeah. And I always tell people, right, because I get caught up sometimes in family affairs, not my family.
Especially
And-
if you have to do like accounts
And
review
I
for
always tell people to, just ask yourself, what would my father, mother want?
them. Yeah.
These are their children. Come on, man.
Yeah.
That's their children. Share it equally.
You would think so, but people are people.
Don't act like it's yours. It's your parents' estate. Share it among your siblings.
Uh-huh. And
That's
then
what
they'll
your father,
say,
mother wanted.
but so-and-so wasn't there, and so-and-so wasn't there for Ma and Pa, and I had to go to Cayman Islands with them, and da-da-da-da-da, and they didn't know how the funeral get paid for, and
I know.
we're dealing with people.
Yeah, I know.
And that's why I always say, as the person who's alive and well, take that argument away, or the opportunity for an argument away, and make the decisions while you're alive.
All right. So, is there a timeline for the administrator to administer the will? Is there a timeline up?
Well, it's supposed to be as quickly as possible and as reasonable as possible. So you'll have instances where things get done very quickly because maybe it is property that is eligible for sale, or maybe there's bank accounts that funds can be divided very quickly. But if the estate is complex, it may take time. But what we have seen in practice is about 2 to 3 years
2 to 3 years
is reasonable
So-
to dissolve an estate fully.
Okay, so what? Okay, what if it take? What if they don't act on it, like say 10 years or 5 years?
Application to the court. Again, the beneficiaries always have a power to go
They
back
could-
to the court
They could go to the court.
and say the administrator is failing
not
in their
acted.
duties. Yeah,
All right, but
and the court can replace
but if you
them.
don't take it to court, can it become null and void?
The administration?
Uh-huh.
No,
No.
no. It's always until the estate is dissolved.
So it's best if they do not act on the will. It's best that the beneficiaries take it to court.
Yeah.
And it requires all the beneficiaries to take it to court.
Again, the ones who are interested in it, and as long as they have the consent of the other beneficiaries, or then you'll get into a beneficiary war. You'll have Group A, Group B, Group C, with their different viewpoints on it.
I see. I see. And
But you can have a single beneficiary
You can have a
take a
sing-
trust, an executor or administrator to court for saying that they think the estate is taking too long to be
yeah,
dealt
so,
with.
So that's what people should do then. If they think it's taking too long,
Yeah.
then they should take it to court.
Yeah, exactly.
What if they suddenly come, I don't know, 5 years later, 10 years later, it still doesn't matter.
Who suddenly comes?
The administrators say, I'm going to.
Come later and deal with it?
Uh-huh.
I mean, it's up to you. It really depends
Yeah.
because if there aren't many assets, say the asset is a home
Mm-hmm.
and the spouse is living in the home, and you're like, okay, we're fine with Ma living there
Yeah.
until Ma passes, then she passes 10 years later, and now you're like, okay, let's sell Daddy's home, or let's,
Okay.
you know, it really depends.
So there's, all right, no problem. And like you say, that option to the court.
Yeah.
And how does the execution of the administration takes place? Do we call a family meeting, or we WhatsApp, say, hey guys, I'm the administrator? Do we email? What do we do?
The other beneficiary should know before then, because
Before then?
remember, they need consent.
Oh,
You need their
okay,
consent.
okay.
So if you're stepping up to the plate
Uh-huh.
to become the administrator, then you'll need consent. And during that process, again, be open, be clear, be honest, because what we haven't touched on is debt.
Mm-hmm.
The estates, if an estate has debt, that may put people off too coming forward to administer on
What do you
it.
mean if the estate has debt?
The house, maybe the mortgage isn't paid on the property.
that.
Yeah.
Sorry. Mhm.
Or other expenses that may have arisen.
Mhm.
Maybe there's some medical debt. Maybe there's money for
understand.
credit card
Liabilities.
I should have used liabilities with an accountant instead
All
of the
right,
word
I
debt.
understand. I understand. So
So you're responsible for them, not personally. The estate,
the estate
is responsible for
so
them.
they need to make sure that's taken care of before they even distribute.
Yes.
Say they sell something.
Yes.
They should really.
cover the liabilities first. And any attorney who's assisting you in drafting your will make sure that there's a clause in there that provides that any liabilities must be covered before the distribution.
Because I would think, though, also that, Honorable Akierra, that if the estate had debt, I would assume that whoever they had the debt from would have had some charge on it. No?
Could do, but remember, people take personal loans
Oh, okay.
without security,
Okay.
and credit
Okay.
cards, because credit cards are unsecured.
Okay.
And so in that instance, and sometimes you'll find the banks taking a lot longer to unfreeze accounts when they're owed funds.
Okay, I see. I understand. I mean, anything else you think we need to talk about for clarity? To
Not
people
for clarity, because it's a wide area and there's so much nuance in it. But what I want to encourage your listeners and friends of the show to be mindful of, we don't know the date, time, or hour of our end. And especially if you have children and assets, you want to make some sort of decisions for them while you're able to do so now, than leaving it towards the end when you've now passed, the family is grieving, the children are upset, they're hurt. You know, death is very hard to mourn, and the grief of it never goes away. We just lost Miss Gladys Forbes over the weekend, and Miss
That's
Gladys
your mom's
Forbes,
neighbor, your grandmother's neighbor.
and my grandmother's best friend. I actually have a painting that I commissioned of them sitting on the wall from the memories I have growing up. And losing Miss Gladys just brought back all the memories of losing Grammy. And this weekend was rough. Like, I was full of tears mourning for Miss Gladys and Miss Grammy, knowing I'm never going to hear Key and Al and the nicknames again. And my Grammy passed almost 15 years ago. But the grief, you know, it comes.
It brought back.
And so I say that to say that you're in a position now to take away a burden from your family later on.
Yeah.
And just take the time out and do it. And as I say, I know lawyers, we're cost prohibitive. We can be expensive in this regard. But there are online templates that you could start with. I know everyone's using ChatGPT these days, so I know ChatGPT can help a couple of people there. But just have the basic information. Make sure it's labeled your last will and testament. Make sure it identifies you fully. So your first name, middle name, second middle name, because I have two middle names, last name, last address. Identify what it is you want to leave or how you want affairs to be distributed, whether that's property, bank accounts, jewelry, anything that's of value to you that you want to pass on, artwork, etc. Identify who you're passing it on to. Identify a person who you believe will carry it out your last wishes, signed by two independent witnesses, and keep a copy in your house. Keep a copy at your office if you have an office, and the person who you want to administer the estate on your behalf, give them a copy and keep it safe. You don't have to use a lawyer, but if you can afford to, I would obviously recommend it. But don't leave it in limbo. And remember, we are all going to die. So having a will is not going to make it any faster than it already will be when it's your time.
And
I think that's the best advice.
Yeah, and we shouldn't assume that your estate will be distributed fairly and equally.
No.
We should not assume that, especially if you have kids before marriage and outside marriage to different women or men.
Because the mothers of minor children can also petition. So because a minor beneficiary can't sign off on consent and can't represent themselves, so you'll have their mother or their father also involved in the mix. So just make it easy for everyone. That's my view on it.
So I'm not sure I understand this question, but they say, what about settling the deceased liability? I'm not sure.
That means paying off the debt. So what about it in the sense that it needs to be paid? Because I think we covered it. That message probably came in while we were developing that point a moment ago. But that is a requirement because the lenders or any creditor, they have the ability to sue the estate of the deceased. And we've seen it. We see it in the newspaper when houses are being auctioned. You know, it may not have a person's name. It'll say the estate of XYZ. Creditors are going to come.
Because
they need people say,
that's their money. Actually, they they want to get paid. You know, so that's and
they'll have
fair.
sympathy for the first few days, but after a while, you'll start getting calls with what's the update. And normally, I think they tend to wait till after the funeral.
I mean, that's the outstanding debt.
And
especially if they know the estate has assets and. Which you can liquidate and so they can get paid.
And settle it.
Well, I want to encourage families to please have a will. I think it's very important. I've seen too many families fall apart after death of a loved one. Families who you thought was so closely knitted, and now they're enemies. And we don't want that.
No.
We shouldn't have that. God created us as a family. And families should be together. And sometimes many of us we become so greedy after the death of a loved one. And like Akierra said, we say, "Oh well, I helped my dad. I helped my," Yes, you help them. Yes, you help them. But your siblings, unless the will says something else, your siblings have equal rights. They have equal rights. Whether they were born, whether they are your mom's children or just your dad's children, they have equal rights. And you have to remember that. That is your father's estate or your mother's estate. And their children should be entitled to the same as you, whether you help them or not, whether you were there or not.
Yep.
And for those of you who are not, you know you're not married, you know you're not living with your spouse. And I know I'm a Christian, I probably shouldn't be advocating for divorce. But you've been separated for years. Get a divorce.
It's actually easy if they've been separated.
You've been separated for years, right? You died. And then that wife or that husband who you haven't been living together with for 10 years has 50%. Is entitled to 50%.
Talk about rolling over in your grave.
And you know that you and your spouse are not together. But legally, you are entitled. So I don't know why some of y'all stay married when you know you're not married. Honestly.
But they say cheaper to keep them?
I don't know, but I think
don't
it
know.
creates too much
It
issues.
creates a lot of confusion.
So that's a big issue.
Yeah.
And then sometimes, and please don't call those children outside kids.
No,
they are
that's your brother and
children.
sister. That's it. End of.
Those children are innocent. They didn't ask to be coming into this world.
No.
They have the same rights as you. I have one more question from
Yeah,
someone.
sure.
All right, let me just read this question. What if the wife is not included in the will, and all their assets are aligned in the will? What if she's not included in the will?
Was the will done before the marriage? Because if it's done before the marriage, remember, it could be
You have to have the-
challenged.
Well, let's say after the marriage.
After, then that's fine. That's the spouse's decision on how they want to distribute their assets.
So if the spouse is not included in the will, the wife does not get 50%?
No, that's
that
only
right?
if you die intestate with no will. The legislation makes a provision thinking that 50-50 two become one. But if you are married and you draft your will and you decide who you give a gift to. The law does not require you to give a gift to your spouse.
Okay, so only if there's no will.
Yes, 50% is automatic.
I see.
Yeah.
So that's another reason why we should have a will.
Exactly. That's what I said. You decide who you're giving your gifts to, not the court and not the legislators. But if you decide to go and meet Jesus without your will, then the court's going to say, hey, you were married, 50% to the spouse, 50% to the children.
Yeah.
Call it a day.
All right.
Yeah.
Very good. Thank you. Now, by the way, I just want to say I have to be very careful what I say sometimes on the show. I'm not advocating for divorce.
No, we're not advocating
I'm
for
just
divorce.
saying if you've been separated for 10 years,
Yeah, stop
why are
wasting
you not
time.
divorced?
Yeah.
Come on now.
Unless you're going through marriage counseling. We do believe in marriage
Yeah, yes,
counseling.
yes.
We're big proponents of marriage
Yes,
counseling.
I just want to stress that point because there are people who I'm aware of who has died, the children who we call outside, they are looked upon, they're not involved, the wife, so that's why I stress that point.
Yeah.
If you don't want to be married to a person, then you should just get out of it.
Well, one of my first probate experiences was something like that. Married couple, been separated, must be about 5 years. Husband passed away, wife turned up, 50%. Completely different life, moved on, had children with other people. But hey, they were not divorced.
Yeah.
So the law was the law.
Yeah. I know a situation the other day, something happened. They were separated.
Yeah.
And maybe I shouldn't say this. And she thought the husband was dying, and she showed up.
Wow.
But the husband didn't die.
Thank the Lord.
The husband didn't die.
I hope you wrote a will, though.
I hope the person wrote a will.
I hope you wrote a will
the
now.
person wrote a will. Anything else you want to share? before
No,
we
just to
can?
say once again, thank you to Financially Speaking for having me and your audience, your friends, your listeners of the show, and to plug my new show we were discussing earlier on RTC, Law Abiding Citizen, which I'm told is every Monday at 11:30. So I look forward to further dialogue on legislation like this and breaking down the laws of the Turks and Caicos Islands so that we all understand what the laws are that we're living under and how we can enforce them. So once again, thank you for having me, and I hope that this was helpful to your
Absolutely.
listeners.
It was very helpful to all of us, actually. So you've been watching Financially Speaking. I really believe that this was an informative show. If there's one thing you take away from the show, it's to please get a will.
One time and done.
Get a will. Get a will. And if you think you cannot afford to get the will by going to a lawyer, even though she is in the business, she's also giving you an option that there are templates online.
Yeah.
So get a will. You do not have to register the will at any deeds. You do not have, as long as you have two witnesses who are not beneficiaries, have two witnesses, have a will, and have other people, maybe one or two people with the will. So, someone say, someone can make up a will and say this is the will. But at least you did the will and give it to 2 or 3 different people to hold for you.
Yeah.
And at least when 2 or 3 of the same thing shows up, then more than likely it's probably legitimate.
Yep.
So please get a will. If there's one thing from the show, get a will. It doesn't mean you're going to die soon.
No.
You may die soon anyway. So
We don't know.
you might as well get a will, because
One
I'm
time
telling
and
you, too many families are falling apart over estate management.
Yeah.
We don't need that. Have a great day. Thank you for watching Financially Speaking.
Oh,